Hi, and welcome to another edition of the Trustcast Show. And we're really happy to have with us Paul Slager. And Paul, welcome. First, welcome, Paul. I appreciate you coming on.
Thanks, Zane. I appreciate the invitation.
So today's guest, he won a $12 million jury judgment against the Boy Scouts of America for covering up decades of child sexual abuse. And at the time, it was the largest compensatory award in Boy Scout history. He's the only attorney with 3 cases in Connecticut's Personal Injury Hall of Fame. He took on Yale University for a family of a graduate student who was murdered in her own campus lab. So you've represented families after murders, explosions, child sexual abuse, catastrophic medical failures. What is it about the cases nobody else wants to touch that draws you in? For some reason, you're breaking up on me right now.
Yeah?
Oh, there we go.
Is it better now?
Yeah, I don't know what happened, but yeah.
Okay, I apologize. What I was starting to say is I think it's because I like to help people, and especially people who really need the help. And, I come from a family of people who serve people. My father's a social worker. My mother's a special ed teacher. And so sometimes I feel like I'm a social worker or a special ed teacher in lawyer's clothing, perhaps underqualified for either of their positions. But I like to work with people who have been through terrible things, and I like to be part of making them feel like they've been heard and finding what I consider to be a just result. And honestly, if I don't think pursuing a case is going to lead to a just result, I'm just not interested in doing it.
So you went to University of Michigan for undergrad and law school. Was trial law always the plan, or did something pull you in to that kind of work afterwards? Or
I knew I always wanted to work in the courtroom. I knew I wanted that to be a big part of my practice. I'm not sure I knew that until I already had a few years under my belt that I knew that I wanted to work with individuals in this way. I started off at big law firms in Chicago where you really don't represent individuals. You represent Fortune 500 companies and insurance companies and all the people who are now on the other side of. I found that work to be very unfulfilling. I found that when I was in meetings and depositions with opponents, sometimes those opponents with people, I felt like I would be a lot more comfortable sitting next to them than across from them. And I think that dawning took several years for me. But once it set in, there was just no question in my mind that this field was the one for me.
so when you were looking at that originally, where somebody was sitting, were you on the other side at one point?
Sure was. My first 6 years in practice, I was in Chicago, and I never represented people at all. I represented industries. I represented large corporations. I represented insurance companies in a number of different kinds of cases. Some of those cases were more commercial litigation type disputes, but some of those cases were catastrophic personal injury cases where there's one case in particular I think about that made a real impression on me where the plaintiff was a quadriplegic. And I spent a day taking his deposition, and it took me about 10 seconds to realize I wasn't comfortable in that situation, not because it wasn't an honorable or respectable job, just because I don't want to be in that chair. And I felt envious of the person sitting next to him and supporting him and trying to find a life for him moving forward. So, so to answer your question, that's a roundabout answer, I suppose, but I think it took me a little time for me to really understand it. But once I did, there was no turning back.
No, it's just good kind of, to get a background understanding, what kind of drives people or drives you in this case. So you said you have a genuine affection for the people that you represent. What does that actually look like in practice when you meet someone and it's involving the worst day of their life?
Well, it means lots of hugs. It means difficult discussions. It means holding hands with people, crying with people, listening to people say things that they're not comfortable saying to other people. It means a host of it really means sort of becoming a temporary part of someone's family. And maybe that's too strong of a statement, but I like to think of it that way. I mean, sometimes when our case ends, our relationship doesn't carry on indefinitely, but I would say by far of the majority of the time, I stay in touch with people many, many years after their cases end, because they're really, for me, the juice of what we do is becoming part of people's lives and being an advocate for people who really otherwise wouldn't have one.
So yeah, on a personal level, I was involved in a court case, and I still think about that attorney, and that was over 30 years ago, 35 years ago. Still to this day, he changed my life and the lives of some other people in my family. So
I'm glad. I'm glad to hear that. I mean, I think for people who are sitting in the lawyer's seat in relationships like those that we have with our clients at my firm, you have an opportunity either to be part of the problem, part of the frustration, if you're not returning calls, if you're not talking to people, if you're not treating them like human beings, if you're viewing them as just another file, that I think has potential to have lasting ramifications that are negative. And I think on the other side of the coin, if you do it the way we try to do it, it can be really a lasting positive and a very powerful lasting positive influence on people. And that's the fun part. And that's what we try to do.
So you only take cases with serious consequences. So how often do you say no, and how do you handle that?
Well, that's sometimes very difficult. You're right. I would characterize our law practice as being sort of a low volume, high value caseload. So we intentionally try to restrict the number of cases we take because we want to give each case the attention it deserves. And that does mean that there's a lot of times where there may be a meritorious case, and it may be a case that not only has merit, but has had a significant negative impact on someone's life. But it may just be that because of the way we're staffed and because of the natural limits we have to have, the guardrails we have to have on our practice, but we really can only take the biggest cases. And sometimes we're wrong about what we think the biggest cases are. But we have to use our judgment in that way. And sometimes it leads to difficult conversations. And I think all you can do is be honest with someone in that situation. And there's no question some people are resentful when you don't take their case. But most of the time, if there's a meritorious case, someone's willing to take it. And there's lots of other really competent lawyers in our jurisdiction who can handle cases like that. And we feel that we're doing a real disservice to the people we have existing relationships with if they take too many cases, especially if they aren't doing cases from us.
So are there just you and your partner in your practice that are the ones practicing, or do you have some other under attorneys?
Yeah, we have a number of partners. The founding partner, Joaquin Madry, and I, we started the firm together along with the third partner, Paul Slager. The three of us practice at another firm here in Stamford, Connecticut for a number of years. And so we split off from that firm to start our own practice. And we also have two other partners, Jeff Wisner, who's both a physician and a lawyer, and then Gretchen Randall, who's a long time, she practiced primarily medical malpractice defense for a number of years, and I actually had probably over a dozen cases against her, and we thought she was a good one, and so we recruited her, brought her over. So those are our partners. And then we have one more attorney who's a little older than the rest of us, who is of counsel, and he had his own. He's of counsel to the firm, comes in the office every day. We work closely with him. But he had his own law firm for over 40 years in Stamford, and he really is a nationally known expert particularly in the field of traumatic brain injury. So we have a number of traumatic brain injury cases. So his addition has really brought, a rich library of knowledge to our firm, and he's just been a great addition for us as well. So we have a full team.
So walk me through the Boy Scouts case. So you represented a man who was sexually abused as an 11-year-old. So I have to read this to make sure I get it right. In his troop in the 1970s, I was, I guess I was earlier than that, but, and you used a legal theory that had never been tested at trial. Can you kind of, walk through that?
Sure. Traditionally, where there's been, the Boy Scouts, there have been other cases against the Boy Scouts, but traditionally, pursuing those cases required proving that a particular scout leader who was an abuser had been, that the Boy Scouts, either the Boy Scouts or their local council, had specific knowledge and ignored it, that person was a threat to children. This case, there was no specific knowledge of the abuser. And in fact, the abuser in this case was a senior scout member who abused a younger scout member in his own troop. So there were two two minors involved. And what was unique about our theory, and it was a theory that, to my knowledge, this was the very first time it was advanced to the point of going to trial, was we specifically argued that the Boy Scouts had no specific knowledge of this particular individual threat, but that they did have general knowledge. They had general knowledge that scouting activities were burdened by over and over nationwide, not only just within our home state of Connecticut, but across the country. They're burdened by instances of abuse. Oftentimes, abusers would abuse child after child after child after child. And so we believe that because they had a treasure trove of information, and they literally had thousands of files reflecting abuse in various places, in various troops across the country, and also internationally. And what we believed and what we urged the jury to believe, and the jury eventually accepted, was that having that sort of knowledge imparted on them an obligation to take safety precautions in anticipation of that risk. In other words, you didn't need to know an individual scout leader or a senior scout, as it was in this case, himself or herself, in occasional instances, was a threat. You knew enough by virtue of thousands and thousands of other instances that you knew the threat was out there, and you knew that this was happening, and it was happening with some regularity. So that was a theory we brought to the jury. The Boy Scouts challenged that and said that you need to show specific knowledge of a specific actor being a threat, and knowledge of that by the Boy Scouts. We rejected that, and the court agreed that we were allowed to advance that theory, which we did successfully. We got a really meaningful recovery for an absolutely terrific person who had really endured and still to this day is enduring a lifetime of suffering as a result of being abused during scouting activities. It's interesting because in the wake of that verdict, I've been accused a few times of being the reason eventually that the Boy Scouts went on this bankruptcy, went through this bankruptcy. And I think that's really overstating it. But what did end up happening after this case and after this verdict happened is people took note, not just here, but across the country. People took note and started advancing that theory. And there's no question the evidence was out there that the Boy Scouts had a very, very widespread general knowledge of the risk of abuse. And so once that theory started being advanced across other jurisdictions, especially in large populous states, Pennsylvania, California, New York, Texas, Florida, states like that, the Boy Scouts was really overwhelmed with cases. And that led to the very unfortunate outcome of the bankruptcy. Unfortunately, really, for survivors of abuse.
Right. So you had so actually my family in my family tree is Lord Baden Powell. So I've kind of an attachment to the Boy Scouts.
Yeah. Listen, I was involved in scouting myself, and so I think that was helpful in pursuing litigation. I think as a scout, and you probably feel the same way, you're taught some really terrific values and some really terrific notions, and it was so ironic to me and really disturbing and offensive to me that those principles that kids are taught in scouts were just abandoned by leadership at the highest corporate level. So I felt that that was really a good fight.
So my dad was involved in scouts. It's forever. But you presented evidence that there was things in their files dating back to the 1920s. How difficult was it to dig up that kind of evidence? That seems like
It was difficult. I'll give that as a short answer. It was very difficult. As you might expect, the corporate entity, Boy Scouts of America, fought very, very hard to prevent us from gaining that information. And I didn't get it through production by Boy Scouts of America. Someone sent it to me. And if I remember correctly, it was anonymous even, said, look, and I don't know if this was a former Boy Scout, to the corporate leader, executive level person, but I had access to a lot of files, which I think I had access to those even before they eventually became publicly known, because there was a court order on the West Coast that ordered that those had to be disclosed, and then they were posted on the internet. But before that, I had all those, and I spent a lot of nights and weekends reading through some very, very disturbing things in those files. And the Boy Scouts of America knew all those contents before anyone else they wrote it.
It's kind of like I'm a Reformed Catholic. I mean, I don't mean the same sort of way that I just I could no longer support that because there wasn't enough that was done in my humble estimation to protect the people that it just continued on to this day actually, but that's another.
And I think that the magnitude of the injury somehow you feel more acutely when it's like the Catholic Church. You hold a religious institution to a standard that should be higher than your average corporation, not lower. And the same with Boy Scouts of America. This is, what's more all American? It's baseball, hot dogs, apple pie, and the Boy Scouts of America, right? So you have this image and really this expectation, and I think it's a fair one that they would be principled at the highest levels, and I think that's true for the Catholic Church too. And so when the curtain was pulled back on that, it's just so disruptive and painful to see for people who are affiliated, but also for outsiders.
Yeah, exactly true. So the jury awarded $7 million in compensatory damages, and the judge added $5 million more, and then the Connecticut Supreme Court overturned it in a split decision. How did you process that as an attorney?
Well, it was difficult. It was the reversal of the jury verdict was painful because it really was on a technicality in the truest sense. It was the argument by the Boy Scouts of America was that the jury charge, in other words, the instructions that were given to the jury after weeks and weeks of evidence, really it was missing a few lines, and that was hard to take away a jury verdict like that, especially having sat side by side with a survivor who had the courage to step in front of a bunch of strangers and tell a story that had been tormenting his entire childhood and adult life. So that's a difficult thing to process. I have to say, it's much harder for my client than it was for me. It's a setback, and you hate to have those as lawyers, but it's really about the experience of the person you represent. So that was difficult. That case resolved shortly after that appeal. I must say I was licking my chops to have a second shot at the case. And again, that's a difference between a lawyer and a client. I mean, you hurt for your client, but as a lawyer, I thought I could do better next time. And I was committed to doing that. And I think it was the right thing for the client to settle the case and settle at a level that changed his life forever. So we were able to accomplish a lot of good. And I also think, like I mentioned earlier, there were long-term ramifications of that theory being successful. I mean, it was a surprise for a lot of people that we had such an outstanding result on such a untested theory. So I think when that then started being used more, I think that he felt very fulfilled to know that what he did was something that other survivors of similar experiences were able to take advantage of, to change their lives and to seek answers for what happened to them too. So in that way, it was still very fulfilling. But of course, it's painful to have a victory like that taken away from one of the people who we've grown to really know and love.
But at least it was out there, and when it happened on a technicality, the other side saw the writing on the wall, and so he didn't have to go through the entire process again.
Yeah, I mean, listen, they had very sophisticated people analyzing the case. Although it was the same people who made a determination before we started that trial to offer nothing to settle the case. They said they felt the case had zero value. But when those people, I think, learned the lesson from that, they clearly had a different approach. And I made it clear to them I was really looking forward to a second chance because I thought I could do a lot better. And I don't know if that ever would have happened. You never know when you put a case in the hands of six strangers. But
yes.
But we were able to settle it in a way that prevented this guy from having to go through that experience again.
So I'm going to ask you about another one that's kind of, emotional. You represented the family of Annie Lee, a Yale graduate student murdered in her campus 5 days before her wedding. What was the argument against Yale?
Well, the argument against Yale there and the allegation we had against the university was that the perpetrator of this really terrible crime had a history that they were aware of opposing what I would characterize as a threat to people who worked in the lab. He was a person who really, his position in the lab was he was essentially a custodial worker who cleaned the mice cages. This was an animal testing lab at Yale University. And he was very secretive about what happened, about the experience. He never talked to anyone about it. He never talked to the press. He didn't talk to any lawyers. So no one really got his perspective, but we were able to uncover some evidence that we felt put Yale on notice, that people, especially someone like Annie Lay, who was a woman who worked on her own at odd hours in the lab, just like any of the people who work in those labs, that someone like that requires additional safety measures to be taken, particularly if we're going to have people in the lab who we believe it's reasonable to expect could be a threat to someone. We found instances where the cameras weren't functional, certain security measures weren't in place. We found, like I said, we found really that and we believe we could have proved, had that case not resolved, that Yale was ultimately going to be responsible, putting her in a vulnerable position of being alone late at night within this lab with this particular personality coming and going.
So I have a friend of mine who is an expert in electronic discovery. How much of this it revolves around that kind of discovery, and how much of it is shoe leather?
Well, I think it's somewhere in between our practice. We have, I think where we see electronic discovery, e-discovery as they call it the most, is in our medical negligence cases or medical malpractice cases. And that's because medical records now in the United States are pretty much universally electronic medical records. So, and sometimes when we request medical records, in fact, most of the time, what we get is actually a paper printout of an electronic medical record. And that sometimes the right hand doesn't talk to the left. So the printout we get can be bordering on incomprehensible. It takes a lot of extra time to try to figure out a printed page from something that's designed to be seen on the screen. So there are times where we see or have suspicions that records have been added to or altered, things like that. And in that case, we actually have to have a full audit trail of the medical records, which actually tells every time someone accesses a particular record, doesn't necessarily say exactly what those changes are. But that's a situation where we have to delve into the electronic systems a little bit more and things like that. But otherwise, we are still usually dealing with some sort of written form of an electronic record more than we are e-discovery. I think some of the big commercial disputes and things like that are dealing with a lot more e-discovery than we typically do in our normal case.
So you also represented the family of a 6-year-old boy who drowned. This is almost hard to talk about, when he was trapped in a defective pool drain, and that became the largest individual civil settlement in Connecticut history. What happened what happened with that?
Well, it was a child. This is a terribly tragic case for an absolutely beautiful family where a child was entrapped in a pool drain. There are very strict code requirements because the suction forces on pool drains are known to cause entrapment. There's a long history of that. It's well understood in the pool and spa industry. And the code requires that there be 2 pool drains and that they be a certain distance apart. And that's to prevent a situation where someone's hair or clothing or arm or hand fully covers a drain, and that suction force then holds that person or traps that person underwater. Mm-hmm. The reason you need 2 drains is when that happens is the other drain will then function as a pressure relief. So the person will be released. In this case, a pool was installed and then permitted by the town of Greenwich here in Connecticut to be put into use, despite the fact that it didn't meet those code requirements. And so a child, as this happened, unfortunately, several times, became trapped in the pool drain and died as a result.
Yeah, that's tragic. So,
it's a case where I don't think I had a good night's sleep the entire time that case was pending, just working on that case and thinking about that. And, obviously the family went through something that was 1,000 times worse. But it's a good example of a case making a difference. This is a family who was absolutely committed to using that case as an instrument of change across the pool industry, and also just in in the world of water safety in general. So the family has started a foundation from the proceeds of that lawsuit and really has probably saved a lot of lives by virtue of their work and their dedication. It's not just money that they've given, although they've certainly given that. It's also time and effort and commitment. And I think it's all an effort to show that their child didn't die in vain. And it really is, it's tremendously important what they've done. And it speaks to how cases really can make a positive difference. And I think it's a really great example of one perhaps.
So, yeah, because I think at that point, the money doesn't make anything other than you want somebody to be punished. That's part of it. But then, to use it for some good, that's as nice of an outcome as you could get. There is no nice outcome there. So
No,
you represented.
There's no good. I want to just add one thing to that. That this particular family did not want a penny from the lawsuit. They used all the proceeds from the lawsuit. They used to try to make sure this doesn't happen to other children. And so, to your point, money is not going to fix it. But it was important that someone take accountability, someone accept responsibility. Right. And in this case, there was that accountability. Someone did take responsibility. And equally important, by doing so, by making them do so, this family has saved other lives. And I just think it's just a really powerful experience to be a part of that.
How do you manage the trauma? It's not really vicarious trauma. It's actually, you're really part of the situation. It's more than vicarious trauma. How do you manage that yourself, the emotional part of that?
Well, I think I have a mixed record with that, to tell the truth. So I'm not sure I manage it as well as probably I could. I have a lot. I'm the first to say I've been doing this for a long time, and I still have a lot of bad dreams, which maybe is an indication I'm not managing the trauma as well as I should. I think it's a challenge. I think when you work with people who have had terrible experiences, or people who have suffered catastrophic injury, people who have suffered deaths of loved ones, children, parents, siblings, you carry that with you, or it becomes part of who you are because you grieve with people. And I do think that there's a risk that when you do this kind of work, you view the world as a very dangerous place. I mean, what I try to do to manage it, and I think it's not so much a conscious effort as I think it's sort of happens naturally, is you realize how lucky you are. And I think you really take stock each day. You appreciate your family, you appreciate the people you love, the experiences you love. You have to do that because you just can't take anything for granted. So I think one positive thing of being, I suppose, traumatized or re-traumatized over many years is we do realize, well, listen, we're all going to have a lot to be thankful for. And sometimes it's terrible to think that, seeing other people's misfortune reinforces that. But I do think that that happens.
So you served as president of the Brain Injury Association of Connecticut for 6 years, and you lectured on making invisible brain injuries visible. Why is that so hard to do in a courtroom?
Well, I think that when people are listening to the case, when people are serving as jurors and hearing about injuries, they want to see something. And a brain injury, sometimes even the most profound brain injuries, are not something you see. You don't see a missing limb. You don't see an empty chair where someone would otherwise be sitting. So, and when people who have very, very deeply impacting brain injuries can carry on a conversation, as long as it's a linear conversation, as long as the phone doesn't make any conversations on their own. So I think presenting these cases, and really you do sometimes feel like you're presenting a case that can be incredibly life-altering, but at the same time is not immediately obvious. It is invisible sometimes. And that's where the challenge is for those of us who represent those who have brain injury. It's one of the challenges we face and trying to put evidence that convinces a jury that this really was life-altering, but the jury expects to see something very impressive, and they won't necessarily see it.
So that's kind of related to that. You were appointed to Connecticut Legislative Task Force for studying concussions in youth athletics. What what did you, when you were involved in that, what did you find out being involved in that?
Well, I think I worked very closely with really that group was created in large part in response to concerns of parents in some of our communities here in Connecticut who had concerns about the way coaches and assistant coaches were managing head injuries and concussions during the athletic competitions across the state. And so I came to know some others who really were the impetus for that working group in a lot of ways, who became very good voices, vocal supporters of educating and enforcing better standards for coaches and those who maybe didn't understand head injuries, so that people didn't have multiple head injuries in a very limited period of time, which it's now well known has a significant effect on people. So that's sort of how I got involved in that, and who I worked with on that. And I was honored to be invited by some of the legislators to serve because of my experience, the Brain Injury Association, and also handling cases and developing an understanding of how brain injuries happen and how they impact people.
Okay, so I have a couple, some rapid fire that's more shorter. So the moment in a trial that that tells you a jury is with you.
There's no such thing.
Okay.
There's no such thing. No such thing. Every time I think a juror's with me, they're the worst one for me. So that's a trick question.
The toughest opponent you've ever faced across the courtroom?
Oh, I can't tell them that. I can't let them hear that.
Oh, because you don't want to build them up for that or her. The case you turned down that still bothers you?
That one is very easy for me. I'm not going to give too many details, but I turned down a case where a client pled with me. But after I turned it down, came back several times to get me to take it. It was an injury that someone sustained in the gym, a very serious injury that I wasn't convinced I could vote for case for them. And then 3 years later, I read in the newspaper, I think it's a $14 million verdict that someone down the street had.
Biggest misconception people have about plaintiffs' lawyers? There's a lot of them too.
Yeah, I mean, it's hard because, there's plaintiffs' lawyers come in all shapes and sizes. I think a lot of what I would like to think are misconceptions are maybe accurate in some cases. I think this notion that plaintiffs' lawyers are sort of money hungry, ambulance chasers, that's the thing we all hate. And by the way, there are plaintiffs' lawyers who are motivated by money and chasing ambulances. I think it's a shame so they exist, but I think the great majority do this work because they want to help people.
You just hate the broad brush.
Yeah.
So something outside the law that recharges you?
Great meal. I love food.
Ah, well, you look fit though. You don't look like you eat a lot of heavy foods. But I'm not seeing you below the chest here.
There's a few hours on the treadmill, which I would now label one of my favorite activities.
Okay, so after decades of doing this work, has your definition of justice changed?
I'm sure. It's an interesting question. I'm sure it has, but I'm not sure I can pinpoint exactly how. I think I just have more depth of understanding. I think there was a time where I would define justice by dollars and cents, and it's early in my career. I don't define justice that way. I think so many ways to achieve justice, and many of those have absolutely nothing to do with money.
So I guess when you're younger, you have more financial pressures, and so that just changes your perspective, doesn't it?
I think that's part of it. I think it's easier to impress as a young lawyer by large value recoveries. And I think after you've seen those and had those, we're maybe less impressed by that, and you realize that conversations with people, most people are not bringing lawsuits because they want money. They're bringing lawsuits because they want answers, and they want someone to be responsible, acknowledge responsibility for something terrible. Sure.
So how do you advertise for new business? I mean, I say advertise, and I know a lot of lawyers don't like even that word, but how do you market, what's the method that you primarily use to get new clients?
I think there's lots of methods we use. I think the number one method for us at our firm is to be part of our communities. And that includes being on nonprofit boards. It includes just knowing people and caring about people and letting people know that. And that's not an active form of marketing, but I think when you're authentic and genuine, and the people who work with me are all doing it because they care about people. And I think when you're in the community, with people, whether it's through volunteer efforts, things like that. You just get to know people and they start to have a sense for what you are and who you are. And as it turns out, I don't think they teach this in marketing school, but that's a great way to market because people, when bad things happen, they remember, hey, I met a lawyer once who actually wasn't a dirtball. So that's a good start, I suppose. But other than that, we're very active, of course, in our bar associations and things like that. So we do those things as well, which I suppose is a form of marketing, but not really our primary motivation. We just like to be part of this.
Okay, I think we're going to wind it up right there. And so if someone wants to get in touch with you, they have a case, and they think, okay, that Paul Slager, he sounds like somebody I really could help me. How would they go about doing that?
Well, they could Google me or look me up, I suppose. I'm easiest to contact usually by email. Our website is Slager Madry. Slager is SLAGBR. Madry is MADRY.com. Or easy to track down from that. And I think just if you Google my name or look us up, you'll find us. And it's up to me to do that.
Okay, thanks a lot.